Good morning, good morning, good morning. This is Jeremiah J-Man Maneiro with the Maneiro team at Remax Realty Group. And today we have an exciting broadcast for you, the Maneiro Team Real Estate Minute. We're here live with Laura Fleming from Dollinger and Associates. Good morning, Laura. How are you today?
Hi, Jeremiah. It's good. How are you?
Good, thanks. So let's get right into it. Again, if anybody's never seen any of our broadcasts before, this is meant to be educational. Just answering questions that consumers might have, whether they're buyers, sellers, or anybody looking to buy or sell anytime in their lifetime. Today, we're talking about the role of the real estate attorney in the real estate transaction. So, Laura, just tell us a little bit about yourself to start, because people watching might think you're still in high school.
That's okay. I get that a lot. So my name is Laura Fleming. I went to SUNY Geneseo for my undergrad, and I got a degree in mathematics. And then I decided to go to law school. I went to Syracuse for law school, and I actually interned with David Dollinger, who I work for here at Dollinger Associates, for all 3 years in law school. And then at the end, I told him, "You're hiring me, right?" So here we are 3 years later.
Excellent. So you went to Cuse. Go Big Cuse.
Yeah.
We've got a lot of Syracuse fans here that might be watching, so that's exciting. Let's start right off. We have an agenda of things that we're going to go over. So as we do it, I'll bring it up on the screen. The first one is, why hire an attorney who only specializes in real estate? Why is that important?
Okay, I always say there's two reasons that you should hire an attorney that only does real estate. First, because they have relationships with abstract companies, survey companies. So they're going to order your abstract redate and your survey right from the contract. All right, when you sign the contract, they're going to order it, and that's going to start getting worked on right away. Attorneys that don't real estate and don't have these relationships, they wait until the mortgage commitment comes in, which, as you know, that can be, a month or two after the contract date. So if they have to recreate the abstract from start, you're never going to meet that date in the contract. There's just no chance of it. So ordering it from the start is huge. It saves a lot of time. And then if, something does happen, it does fall through, I mean, the chances you're going to sell the house anyways, or we have these relationships and they're going to, kind of be like, okay, well, you send us all of this other business. We're not going to, worry about that. Second reason I would say is because I've noticed that if it's not a real estate attorney, they don't really know what the custom is for charging fees. So I've noticed that the fees for non-real estate attorneys are a lot higher. Because in Monroe County, it hovers around $500, and that's pretty much the standard. But if you get attorneys that don't do real estate, I've seen it be $1,000, $2,000, $3,000.
Right. And just to add a little bit more to it, in the real estate transaction, like, time is of the essence most of the time if it's something related to the contract or a closing. And to have an attorney who specializes in real estate and be able to contact you, like if I have an issue, I can call you and say, Laura, we have an issue.
Yes.
Somebody who doesn't just do real estate, they could be in court, criminal proceedings. They could be in a divorce case, something where they're making a lot more billable hours than somebody who just specializes in real estate. They're only working on the transactions that they're working
and
on.
Get it. Everything is this.
Exactly. Because if we have an issue, and like, it's all about service, right? So if a client calls us, we want to be able to answer that question. And sometimes we can't answer that question without talking to you, the attorney. And it's great to get, call you call us right back, or an email, or whatever the case may be. And I think it's not like other attorney-client situations where if they call you, you're not billing them a quarter of an hour, right? Or half an hour.
Oh. Yeah, it's a very, very different type of law, way more fast-paced, and gotta use a real estate.
What are the best ways for them then to find a real estate attorney, and when in the process is it good to kind of align themselves with one?
So best way to find an attorney, I would say, is referral from the realtor. I mean, you guys work with us every day. I mean, you've worked with probably most of the real estate attorneys in Rochester. You know who's good, you know, who does what, and you form the relationships with us. So I think that Realtor is the best referral source. You can also, you know, online, you can, you know, check out the attorney's website, you know, make sure you like what you see. What was the second part of your question?
Oh, at what point does it make sense? Let's start with the seller, like with I'm putting my house on the market. Should I contact you then, or should I wait until I have an offer?
So yeah, I take a lot of those phone calls. You know, people want to know, you know, what we charge, what the process is going to look like. I'd say it's better to know upfront who you're going to use. That way you get a contract. There's no delay. You fill it out, you send it in. Same with the buyers. If, you know, if you're looking at houses, you want to put an offer in, know who you're going to use.
Okay. And would you say, well, we'll get to the attorney part of it, the title side of it in a minute, but so what is the role of the attorney in real estate? I have clients ask me, like, you know, what are they doing all day? Like, you know, why does it take so long? Especially people who come from title states who are relocating, it blows their mind how long our closing process takes. So maybe just give us an overview, broad overview of kind of start to finish what you guys do in the transaction.
Okay, so whether we're representing the buyer or the seller, we start off with calling you to do the attorney approval. So we call the client, we go over the contract, make sure everything is as they understand it. You know, they know what they're getting into. And then we issue our approval. And then if we are the buyer's attorney, basically, that's kind of a waiting game. So the buyer has to go and get their mortgage. That's their responsibility. Go sit down with your loan officer, apply for your mortgage, get the bank everything that they need so they can issue your commitment by the date on the contract. Once we receive the title documents, which consist of the abstract of title and the survey, along with all of the proposed transfer documents like the deed, we do a title exam. You know, we go through the abstract and everything, the survey, make sure there's no open prior mortgages, make sure there's no major title issues, make sure that the survey looks good. You know, you're getting what you bargained for, and there's no like crazy encroachments or fence issues or setback issues. Then we basically order a title commitment, which your bank is going to require you to purchase for them. And basically that will list out all of the problems that need to be fixed before closing. And then we make sure we have them all from the seller's attorney. You get cleared to close by your lender. We coordinate that closing, you know, with all three sides, the bank, the buyer's attorney, the seller's attorney. And then at the actual closing, we go through all the documents with the buyer, go over the survey map with them, answer any questions they have, and then make sure it's recorded in the clerk's office. So that's the buy side. When we represent the seller, we do the same attorney approval process. We order direct in their survey. We draft the transfer documents, so we're drafting the deed, and you know, if we need to draft boundary line agreements or anything like that, we'll get the title policy from the buyer's attorney. We'll go through that. You know, what curatives do we need? Is there an old open prior mortgage where we have to track down the discharge? You know, that takes some time. So basically, when we're the seller's attorney, we're curing the title. Making sure we're giving the buyer marketable title. And then, you know, we contact the seller, they come in, we sign their documents with them. And at that point, their role is done. And then we attend the closing, we get the proceeds to the seller, and that's pretty much it.
That's pretty much it.
That's pretty much it.
That's it, no problem. All right, so let's go to the beginning where you said, you know, an attorney approval contingency, because I think, you know, a lot of people don't understand that. We have a contract, right? And it's approved by the Monroe County Bar Association. Us as realtors, we don't practice law. We can't. That's your job, right? And so
Exactly.
what does the attorney, as many as some other agents feel like they should be practicing law, but that's what does an attorney approval contingency mean in a contract? And how does it
basically
buyer or seller?
Yep. So the attorney approval contingency basically means that this contract is still subject to our approval. So we, once we talk to the buyer or the seller, and if we go over it with them and maybe there's something that they weren't aware of or they didn't completely understand when they signed it, this is our chance to kind of fix it. Or if they've decided since then that they don't even want to go through with the transaction anymore, we can completely disapprove the contract for absolutely any reason or no reason. So I guess you can kind of use it. You can use it as a shield, or you can use it as a sword. So it's a protection. You like that?
That's great.
Yeah. So I mean, yeah.
Sorry, I distracted you with that.
Yeah. Okay.
Because I think a lot of folks, you're buying a home. It's a big decision. It's probably one of the biggest decisions you're going to make in your entire life. And I always explain this to the clients, like when we're going over the offer, like, don't worry, we are writing an offer right now. If it gets accepted and tomorrow you change your mind, or the day, we have a certain, yeah,
Mm-hmm.
you can call the attorney and she could just disapprove the contract. Don't worry about it. Like we care more about the relationship than we do about the transaction. Like it's not, people think like, oh, you guys just want to make a sale. No, we want our clients to be happy. And if it means
Yep.
disapproving a contract on the buyer side or even on the
Yep.
seller side, like explain a scenario where you might disapprove a contract for a seller and what that, especially in the seller's market.
Yeah. So right now, a lot of clients want us to hold off on approving the contracts when we represent the seller until the last possible day in the attorney approval period. That way, if they receive a better offer in between receiving that offer and the end of the attorney approval period, we can disapprove the contract for the worse offer, and then they can accept the contract for the better offer. And there's no harm done. It's just done. I just knocked my Red Bull over.
So, and we're seeing there's a couple of different ways that's handled in our market. And every market's different. There's, I speak all across the United States, even in New York, across upstate New York, it's different how it's handled. And we have like a delayed showing negotiations form now where to avoid that kind of disapproval, where let's say it's listed today's Thursday, I might say, okay, it's on the market today, but any offers received from now until Monday are received at the same time, meaning like a delayed negotiation. And then on Monday at 5 o'clock, we're reviewing all offers. And then typically, this air quotes, typically then it's a done deal. Like in good faith, they're saying everybody had their best shot at it, and it goes to the attorneys for approval. Still, in that point, if somebody has sour grapes and says we're mad because we didn't get our offer, they could still, right? I mean, at that point,
yeah,
write a better offer, higher offer.
Reason. Yep.
Yeah, so it's important if you're watching this, if you're buyer or seller, nothing's done until it's closed and recorded in the county clerk's office.
That is true. But yes, you don't. You don't really have a valid contract until both attorneys have approved it. So, if you have a little bit of cold feet going into it, talk to us. We'll go over everything. If you're still not into it, we can disapprove it.
What are some of the other contingencies in the contract that are built in there to help our clients? We're in a buyer beware state where every house you purchase is in as is condition, regardless of whether an agent puts it in the listing or not.
Yep. So obviously we always recommend getting an inspection. And if you're not getting inspection, make sure you know what you're looking at. If you're a contractor or, you flip houses and you know what you're looking at, that's one thing. But if you're just, like me, I wouldn't know what I'm looking at. So I would always recommend getting an inspection. And we always ask if we see in the contract that the buyer is waiving the inspection. We always are like, are you comfortable with this? And you understand the risk involved with that. So yeah, I mean, that's buyer beware.
Buyer beware, caveat emptor, is that it? I remember that from like a test question.
Yep.
Buyer beware. So again, if you're watching this and we're in a seller's market, but the market has to, it balances out. It's going to balance out at some point. We're seeing a little bit in some parts of our market, but waiving your inspection is a huge risk, right? In my opinion, and buyers that we work with, it's like, I don't know if it's worth the risk to get the house, because like you said, with a buyer beware type situation, if they uncover some kind of huge latent defect, meaning like something wrong with the basement, some structural issue, mold, whatever it could be, something that costs thousands of dollars, they can't sue the seller after the fact, right? I mean, because they had
And
their
not unless you prove that they you'd have to prove that they concealed it, and I mean, it's very, very hard to prove. You have to prove that it was intentional, and I mean, you're going to go to court. You're going to spend doing that.
And the amount of money that you would spend, because then you're going to hire an attorney, and that's going to cost money. It's not going to be like a flat fee type of an attorney. And we always see it so many times. People are like, I'm going to sue you. No, I'm going to sue you. And then they call attorneys and they're like, let's work it out.
Yeah. That's it.
All right, let's get into the abstract, because you mentioned that in the role of what you do in the transaction. What is the abstract of title? It sounds so abstract.
So it's basically the history of the property, anything that was recorded, any proceedings or anything that affect the property. It's all compiled into, it's usually on legal size paper and bound at the top. So it's compiled into an official looking document. And basically, in Monroe County, we have to go back 60 years. So, I mean, some of them go back further than that, depending, how long you own the house. Yeah, there's a picture of it. So it's basically just anything that affects the property in one nice little bounded book.
So it's a condensed history. So obviously, like, we have some older inventory, like let's say Cornhill. It's not, you're not going back 150 years. You said it's only 60 years that you have to.
You only have to go back 60 years. A lot of them go back further because the owners have kept it. It's been redated again. So a lot of them go back further than that. If it has to be recreated because the original one can't be found, it does only have to go back 60 years.
Okay.
That's just standard.
Let me just pull this up. We have a little bit of a flow chart that we created so everybody can kind of see. I don't know if you can see that. It looks kind of small, but once the contract is formed, right, what's the first thing? Let's say you're representing the seller, you have to locate the abstract.
Yep. So I always ask, when I do my attorney approval, when I'm representing the seller, I always ask, do you have your abstract of title, or do you know where it is? And a lot of people will say, yeah, I have it right here, and they'll have them drop it off at my office. If they don't have it, and I've asked them, when have you owned the property since? And if it's like more recent, like 2000s, chances are the abstract company is storing it. Just because, 90s and further back, they used to send it back to the client to keep. But now, since they're so expensive to recreate, the abstract companies have been storing them. So what I'll do is I'll put my order into the abstract company, and they send out a search to all the abstract companies in the area to locate this abstract.
And so basically they're just really saying, hey, do you guys have this history of this property somewhere? Is it in a filing cabinet somewhere, or on the computer? Like
storage. Creepy storage.
Because I always wondered, like, where is it? And wasn't there an issue with like a title company that went out of business or something here locally that has some titles too? Is that?
Yeah, who is it? It was I can't remember. Yeah, all of those pretty much have to be recreated.
So if somebody's had it for a while, or like you said, pre-90s, where it was given to them and they can't find it, as an agent, would it make sense, if we have agents watching this, for them when they meet with the sellers to list the house to say, hey, locate your abstract, or find out wherever it might be, so that you don't have to recreate it, because that's a bigger expense, right?
I think
kind of give you like a head start.
Yeah. I'm sorry?
that kind of give you a head start so that they're not trying to
Yes,
locate it
yes,
then?
yes. So, yes, I think that you should be asking them, hey, start looking for it now. It does save time, saves them, I mean, if they're looking for it and they don't find it until 4 or 5 days after I talk to them, we've already lost a week on having it redated. You know what I mean? So asking them from the start, even honestly, once you get a contract for a listing and they have the abstract, I give it to me and I'll start having it redated now. You know what I mean? That way there's absolutely no holdup. Because that is most times what the holdup is.
So let's say getting the head start on it brings up a lot of good points, but what are some of the issues then that can come up?
Yep. So most common open prior mortgages, and a mortgage from a previous owner that was never discharged. So that means that we have to start tracking down the discharge. If it's a bank that's still in existence today, it's a bit easier to find. If it's a bank that, is no longer in business, then we have to find out who they sold to, who like absorbed their mortgages, track that down. Other issues we see are judgments that have been recorded. Sometimes people don't even know that they have a judgment against them.
Mhm.
Most times, though, it's not actually them, it's someone with a similar name. So we could do an affidavit, and that takes care of that. Bankruptcies, we want to make sure the bankruptcy was terminated. What else? I mean, there's other bigger issues that are less common, like if
About
there's
like foreclosures, short sales, and
want
estates.
to make sure the foreclosure was done correctly, all the proper parties were served. Estates, we want to make sure the person selling the property actually has the authority to sell the property. That's a big one. But yeah, there's bigger issues. There's we want to make sure it's a continuous chain of title. There was never a break in the title. So, you can trace back from owner to seller and owner to seller, and there's no break along the way.
So what if there is an issue? Let's say it's an estate and there's a long lost love child. I mean, this is a real life example where they had like an estranged sibling that had claim to the property,
Okay.
and then it's sold to my client, and that person was never notified. I think they would have been could have been an heir to the property or challenged ownership of, or something along those lines. Like, how do you?
Goodness.
Yeah, exactly. So how do you cure things like that? That's what we talk about when you're doing a curative to a
Yeah,
terminal,
yeah.
right?
So, I mean, that could be anything from a correction deed. So, maybe that heir was supposed to sign the deed and they didn't. So we'd have to go to her and have her sign a correction deed to fix that problem, which we've done. We just did one where we knocked on their door. We needed a correction deed because they conveyed the wrong property. The wrong legal description was attached to the deed. So it was actually, they conveyed their primary residence, not the property that they were selling.
Oh my gosh.
So we had to go knock on the people's door and have them sign a correction deed.
That's crazy.
Yeah.
Well, I mean, these are just one or two of the many examples of why you need an attorney who specializes in real estate, because when these issues come up, Laura and Dollinger's office, they can go, oh yeah, it's very rare nowadays that you encounter something that hasn't happened before, that you know how to
Exactly.
solve. If it's somebody who doesn't do real estate, they're like, and then they're like, you got to take care of it on your end. It can really delay the whole process, and everybody's wondering why we're not closing. And it's because one side didn't do what they're supposed to with the title work, and that can delay the whole process, right?
Exactly.
Okay. Let's get to the survey. Survey side of things. What is a survey? And what
All
are
right. So a survey is basically just a drawing of the boundary lines of your property and the measurements. So basically, you can see, make sure you're getting what you actually think you're getting. So it's going to basically just show you where your boundary lines are, what the measurements along each side are. So the total, acreage, Common issues that we see, most common, fences. If you put a fence on your property and it's more than a foot inside your property, then you have a title objection. So we got to send out a boundary line agreement to your neighbor. Basically, they have to say, hey, I know I don't own that little sliver of land between the boundary line and your fence, because it creates what we call adverse possession issues. So fences are very common. Other problems, driveway encroachments. Your driveway encroaches onto the neighbor, or the neighbor's driveway encroaches onto yours. Again, we'd have to send out a driveway agreement, basically where the parties say, hey, we know where the boundary line is. We're going to let the driveway stay here. If we ever replace it, we'll put it on our property. Other issues, setback violations. You know, if the town has a 90-foot setback and your house is only 80 feet back, that could be a problem. There is a affidavit for that cures that as well. Easements, it'll show you where any easements are, so you know, hey, I can't build the shed in the drainage easement, because the town could ask you to move that. Those are the most common, I would say.
What about, and this becomes more common, like when you get into the more rural country, more country settings, where you have like somebody, at one point it was like a 500-acre farm, and it went from 100, then and there's all these parcels that were kind of broken up over the years, and they didn't call attorneys to do it. They just said, hey, Laura, I'm going to give you from the oak tree over there to this rock over here to the road. And then you have like barns that are over one line, and like we had one where a barn was quite literally 5 feet over what the boundary line was. And then,
oh my goodness.
Yeah, it's an issue, because the guy who owns the land, we had to sold 5 feet of land, like sold a little parcel of land that barn sat on, but he held the negotiating position, because it was like, if not, you're gonna have to knock down this barn, or at least saw part of it off, the whole back part of it. Yeah,
yeah,
so
that's another thing. You know, you go and you look at the property, you think you're getting the shed, the barn, and everything, and then you look at the survey map, and those are actually on the neighbor's property. They're not yours. So it's not, what you see is not always what the reality is.
Yeah, and these boundary line agreements, it's important, like you talked about, getting these agreements and curing them and taking care of them. But again, a real estate attorney knows this, and when they're ahead of it, they get ahead of this and say, hey, we're going to need this signed, rather than somebody who doesn't specialize in it. You know, I've had to come up at closing, and I personally have gone to get boundary line agreements signed from a stranger, you know, like knocking on their door and saying, hi, I don't know, you don't know me, but you have to put your social security number on this, and we have to go notarize together. And it's we do what we have to for our clients, but that's something that really should be happening, you know, way ahead of time. Way ahead of time. So as our clients, like sellers, somebody who might be thinking about selling in the future, is there ways that they can kind of get ahead of this and check make sure their shed is set back from their boundary line correctly, or is it just kind of when you do your work, then you're going to bring them up to speed?
Yeah, it's pretty much when we do our work. I mean, if you built your shed in an easement or something, I mean, there's not much you're going to do about it now. It's done and over with. But we know the proper curatives for that. If you built your shed in an easement, it's not the end of the world. The buyer just has to understand that if the town ever asks them to move it, they're going to have to move it. But yeah, I mean, you can always get a permit anyways, but that's besides the point.
We see it a lot of times with the lot line setbacks that are required in some of the towns, where it might be, it's supposed to be 5 feet from the lot line or 10 feet or whatever it is, and they didn't know anything. They wanted to butt it right up to the boundary line. I have moved more than one shed, like 4 guys getting on each corner and picking this shed up and moving it like 2 feet or 5 feet. Yeah, just to make sure that it's but you can't do that with a house, right? I mean, if
no, you can't. Well, maybe some houses.
Some houses. I did have a client where the house sat, it wasn't exactly square to the road, and the one part that was closer to the road, violated the setback ordinance for the town, and they had to get a
Yeah.
variance
Yeah.
because they couldn't. I mean, if they're not going to saw that part of it, it's a brand new
Yeah.
construction.
Leave that portion of the house right off.
Yeah. Okay, now we're good. Yeah. That's funny. All right, so what are any of the other terms and conditions of the contract that you feel might be important? I guess in this market, let's talk about non-contingent buying and or contingent buying and the bump and how that all that exciting stuff might work.
Yeah, love the bump. So for non-contingent, get your pre-approval. Make sure you can actually, if you have a house and you want to buy this with non-contingent, make sure you can actually do that. You can carry both mortgage payments. So you'd want to meet with your loan officer, get a pre-approval that's non-contingent and make sure you can, afford that. Contingent one, so you have to sell your house to buy. You actually have to sell your house to buy. So it's like the completion of the transaction. So while they can't, bump you for someone else at the very end, it is still contingent until the very end that you sell your house to buy this house. So if something happens at the end, your buyer backs out and you can no longer sell your house, then you don't have to go through with your purchase because you didn't sell your house. But the bump, oh, we love the bump. So there's a whole, do I have this with me? See, I brought a contract. I'm so prepared.
Like you're an
So
attorney.
you have to meet one of the 3 requirements on the second page of that bump clause. So you either need, if they want to bump you for a better offer, you either need a commitment letter that's not subject to your sale. Let's see, you need to have the cash to buy it cash, or what was the third one?
Have all contingencies satisfied.
All can be satisfied for your benefit. One note though about the commitment. So if you're able, because I had this issue, if you're able to get a commitment that's not subject to your sale, it still can't be subject to an appraisal. So it has to be
an unconditional commitment.
Yeah.
Meaning all conditions are satisfied on it, right?
Yep. So I mean, you can't, and you got to accept it as well. So you got to accept the commitment. But yeah, the bump, basically, if they get a better offer, they're going to give you however many days notice you negotiated. And you either got to come up with one of those 3 options or lose the house.
No, and I know in years past, there had to be proper service of that bump clause or the bump notice. I mean, and I don't know if the new revision is out, but the new one that's coming out, I believe, is going to be service constitutes service is satisfied when the email is sent to the other parties. Where it used to be, we had to have an actual person, not a party to the contract, serve the person the bump. And if you were representing that buyer that was waiting to receive a bump, you could tell them to, like, don't answer your door, don't, right? Because until they were served, the clock didn't start ticking, so it kind of bought us additional time, right?
Yeah. No, I did hear that they're going to be changing that, like all the notification requirements. So
yeah, it'll be as soon as it's in the sent folder of the agent. Yeah, as soon as it's in the sent folder of the agent or the attorney, it constitutes proper service. So it's just another, again, important for any buyers or sellers who are out there who are in that kind of a scenario to work with the right realtor, because that's where it all starts. Like the timing, having all, if we're working, if the Maneiro team's working with a client and we're contingent, we're going to have all of our ducks in a row. So if and when that bump clause comes, they try to give us that bump notice, we're going to be ready to just go and remove what we need to make sure that our clients are in the best position. And especially in that scenario, like you said, time is of the essence, because we really do, whatever's in the contract, whether it's 1 day, 2 day, 3 days, everybody has to be working together. So it's like, we'll be calling you, and everybody's like, right, trying to make sure that we,
A lot of communication. Mm-hmm.
yeah, it's critical. All right, anything else you want to add? I think we're coming up to a little bit over 30 minutes. I think that's we covered everything that we wanted to. Anything?
Yeah, maybe just one thing, because we talked about earlier, the one thing that's not time is of the essence is the contract closing date. So a lot of people set their hopes and dreams on that date. They hire their movers. They're like, this is the date I'm moving. That is a target date. Target date. So it usually ends up closing somewhere around there, but don't do anything that is so set in stone that if you don't close on that date, it's the end of the world.
Yeah.
And I'm here to go over that in my approval with the client.
Worked with us. You know, I sent out an email that says, you will never, ever, 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 ever close on time. You have a better chance of predicting your baby's due date than you do the closing date. Okay, so please do not take off of work, reserve anything that has a non-refundable deposit, schedule anything, buy anything that needs to be delivered until we have a firm closing date. And the only people that can issue that closing date are the attorneys. Okay, us as realtors can't. All I do is make a phone call. And if I call Laura 10 times, it doesn't mean she's going to go, oh my gosh, we got to get this closing date scheduled. Like there's a lot of parts to the process here that sometimes have to be gone through before we can actually schedule that. So that's important. I'm going to put here, you have a better chance at predicting your baby's due date. And if anybody's had children, you will understand that, babies. How many folks at Dollinger and Associates part of your team there?
So we have, including Mr. Dollinger himself, we have 4 attorneys, and then we have, I think, 10 paralegals. That's a very, very out of date picture.
Well, I get updated. I pull my stuff from the interwebs.
We have to take a new picture.
Yeah. Well, there's you in the middle.
I'm still there. Hi.
Yep. So you have total of what it looks like. Is it 3 or 4 attorneys and then just a kind of a bunch of paralegals in the?
Yep. We have 4 attorneys, 10 paralegals. We have a receptionist. But yeah, no, I mean we're high volume, but we're a smaller, more boutique law firm.
Well, it is all about service, and I think people need to understand that when you hire an attorney, like they're going to talk to you when they need to, but the folks that do a lot of the work behind the scenes are the paralegals who know all the terms, they know the conditions, they know. Again, they're specializing in real estate because it's the only thing that your firm is doing. And I guess lastly, we would want to mention that it doesn't necessarily matter where your office is located, right? You guys are on Monroe Ave in Brighton.
Doesn't matter. Always close at the bank attorney's office. So.
Right. So if I am on the west side, east side, if I'm in this Rush, Henrietta area, it doesn't matter. It's just as long as, with technology, it's just phone call, email, everything.
Okay. Yep. Doesn't matter.
All right. Well, I want to thank you, Laura, for taking time out of your busy day. I'm sure you have many survey, title, closing issues to handle today. Again, thank you.
You're welcome.
Associates, great attorneys to work with if you guys are thinking about buying or selling real estate. First, call the Maneiro team at Remax Realty Group, myself and my better half, Christina Adolph Maneiro. And then you'll probably be working with Laura Fleming once you get to that stage of the process. So thanks again and have a great day.
Bye. Thanks, Jeremiah.
Thank you.